Ms. Farr present. Do I have anyone else on this matter?
Amy Powers for the state of Washington.
Thank you, Ms. Powers. So I think first thing, just jurisdictionally, when we were together last on October 31st, there was still a question about exhausting all methods of service. I'll turn it over to Ms. Farr and Ms. Maddox. Where are we at on that issue?
So, Your Honor, father has now been served. He was in the Clark County Jail, and Ms. Powers alerted me, and then I alerted the petitioner, so she was able to get him served. We don't have a proof of service filed yet. So, but the time period for the response from father is up on 11/27.
Okay.
And we also still need the CPS information.
Right. Okay. Okay. Thank you, Ms. Farr. That is extremely helpful. And Ms. Powers, thank you for your assistance in that. Ms. Maddox, what would you like the court to know?
Excuse me. I'm waiting for the proof of service to be mailed.
Okay.
I contacted them and they said that they were in the process of doing so. So I'm just waiting for that basically.
Okay.
I do have a receipt, but that doesn't show the proof of service.
Okay. And then Ms. Powers, it sounds like, and I don't have them in front of me, but it sounds like the state is proposing child support worksheets. Is that correct?
Our position is that the father's current child support order should remain in place, but we did propose child support for the mother.
Okay. So my thought, unless Ms. Powers, you want to, if we could handle that today, if you want, I haven't reviewed it ahead of time. I do understand it got filed with the clerks though, but my thought is to set this out to a date after 11/27 to see if father files a response. Also to see if we can follow up with the CPS records just to have that marked off. And then we could just deal with all issues in the final order. Would that be acceptable to the state?
Yeah, that's fine.
Okay. Ms. Farr, how much time do you think we'll need? Obviously after 11/27.
I think either the 5th or the 19th.
Okay.
I'm not available on the 12th, but I guess it depends on the CPS timeline.
Yeah.
Can you tell, has that been resubmitted?
I was just going to check with our clerk. Do you know, on this one might have been one that got sent to the old or the former email. Are you able to tell? So what we're going to do, Ms. Maddox, Ms. Farr, is the clerk is going to resend the order since this one was back in June, and that was kind of the time period where we seem to be having problems with CPS getting those. So we're going to resend today. I anticipate once they get that and respond and we get past November 27th, we will essentially be ready to finalize. Ms. Maddox, do you have a preference? December 5th with the holiday could be cutting it a little close. My proposal would be the 19th. I know that's a little ways out. Ms. Maddox, is that acceptable to you?
Thank you.
Okay. Okay, so let's set these issues for hopefully approval of the petition out to December 19, as well as the child support order for mother.
Thank you.
Thank you.
Thank you. And again, that'll be at 10:30, Ms. Mr. Reisenberg, present. Thank you for being here. And I believe we appointed you to the minors in this case.
Yes.
And we also appointed a court visitor, Ms. Farr, for service. And I believe we have had service, but maybe Ms. Farr, I'll turn it over to you to update on that.
Mm-hmm. So, Your Honor, we do have service. Father went to Mr. Rosenberg's office and accepted service for both parents. That's been filed with the court. Both parents have now consented. I have the consent forms that I need to get filed. So I think that we are waiting for CPS information. Looks like that was sent in August, so that may have also gone to the previous email address, might need to be resent, and then we're ready to enter findings.
Okay. Mr. Reisenberg, on behalf of the minor, anything you would like the court to know?
Yes, the minor is in agreement with the petition with a couple stipulations. He wanted a little bit more control over communication with his parents. In particular, he does not want to have to wait for a 30-day period of sobriety before he's able to text communicate with his parents, subject to all their stipulations set forth in the petition. And he would also like to, once that 30 days of sobriety has been achieved, have his own have in-person visitations be at his discretion.
Okay. Okay. So I think let's also do this kind of one at a time. Number one, let's go ahead and resend the CPS order again on this one too. I did not originally put an emergency minor guardianship in place. I think we still have to have a short hearing and enter some judicial findings on whether the court's essentially going to be. So there's at least two potentially disqualifying factors with these two guardians. And because they are a relative, I believe I have discretion to waive those or find that they don't disqualify them. But I think we would need a short hearing on that. So my thought is to set this over both to get the CPS information and to hold essentially a show cause hearing on the emergency minor guardianship petition, where the focus would be, number one, whether the court should find that the criminal history is not disqualifying. And number two, whether the court should find that not having an in-state guardian to serve should not be disqualifying, and or have the guardians propose an in-state person to serve. Does that make sense?
Yes, they just need to appoint a resident agent for service.
Yeah, so if they come back and have a proposal for that, that takes care of one of our factors pretty easily. And then we can focus. I'd like to hold a short hearing on the criminal history factor, and I'll have to make a decision about essentially whether I'm waiving that or finding it's not disqualifying for entering of the guardianship.
And Your Honor, I have interviewed them, and I do have some information to provide the court for that, so I can do that in my report.
That would be excellent. Thank you. Okay, so let's set a date for that. Given that today we're going to send off the CPS request again, what if we also set this to December 19th? Would that be acceptable to the parties?
It is for me. Thank you.
Yes, Your Honor.
Okay. And then to the guardians and Riley, will December 19th at 10:30 work?
Yes.
Okay. Any questions for the court I'll ask guardians first.
Yeah, I mean, my concern has always been, the major concern is at this point, Riley doesn't have any medical insurance, and he does need counseling for sure. And we can't even do that without any kind of guardianship paperwork. We can't even make an appointment. We can't get him.
Well, we talked about this last time. At 16 years old, he can make medical appointments for himself. So I'm not quite.
He doesn't have any health insurance that's valid in Oregon. He has Washington State Medicaid, but it won't work here.
Right. So my understanding is you reside in Portland.
Yeah.
Take him to Washington for an appointment. Right.
Well, the school has a counseling service that they've contracted with, where they have the therapist there at the school. Mm-hmm. It won't work with Washington State insurance is the whole problem. But I mean, if there's nothing that can be done, we'll just wait until December 19th.
Well, I'm not even asking you to wait till December 19th. I'm telling you that there is another solution just 14 miles over the bridge. So feel free to take advantage of that. And then we'll hold a hearing on December 19th. Okay, we'll see all the parties back on December 19th. Mr. Reisenberg, Ms. Farr, anything else?
No, Your Honor, thank you.
Okay. Honor, thank you. Ms. Curry, I see you here. We did have a court order on November 7th in which you failed to appear, which is why we set out the order to show cause. I had not extended the emergency minor guardianship because you weren't here. So let me just check in with you first and tell me whether you're planning to continue to pursue the guardianship.
Yeah, I am. The last court I had COVID, and I'm sorry I was not able to even get on a Zoom meeting.
Okay.
When I talked to Ms. Farr, I'm to the point where it's discouraging because I still haven't been able to get a hold of Emily. She hasn't reached out. Nobody has seen her. She hasn't contacted anybody. And even Brian has gotten to the point where he needs Emily to be able to get his name on the birth certificate. And so it's discouraging at this point, but yes, I would like to continue to have guardianship of Lila. Brian and I work together really well. We basically split everything and figure out, visitation and needs for Lila together. So we're doing good without Emily, but I don't know how else or where else to go at this point.
Okay. And I think I'm going to turn it over to Ms. Farr here in a second. I think the concern when we were last together on October 17th was that the original service appeared to have been done by yourself, and that wouldn't be deemed appropriate service. So that was kind of the hang up originally. Ms. Farr, I'll turn it over to you now.
So, Your Honor, the last communication I did have from petitioner was that they were going to do the best they could without the guardianship. So it sounds like she's changed her mind and wants the guardianship now. So we're back to the service issue. So I'll have to get in touch with her and try to work with her to get mom served.
Okay. So Ms. Curry, that we are kind of back to square one where we do kind of a jurisdictional threshold issue is getting that service done. I do see Mr. Phelps present here in the Zoom courtroom. Mr.
Yes,
Can you hear the court?
yes.
Okay. Is there any input you want to give?
Like Molly said, we're doing just fine as, the way it's been set up. Emily is, I don't know how to get her served, being that I am the father, and if she's not willing to step up or even contact anybody, I don't see where me being the father, why we can't just proceed with this, with me being in agreement and everything.
Yeah, we have to have both parents properly served. That's why. So it's not.
Okay.
And Your Honor, the other issue is if Mr. Phelps is not listed on the birth certificate, he actually doesn't have any legal rights.
Well, that just came to mind too. I did not realize that he was not on the birth certificate.
No, because at the time she was born, I wasn't sure if I was the father, so I waited till I got the paternity test. So I have the results from the paternity test stating I am the father.
Okay, so I need to get in touch with you and we can work with that to get you listed on the birth certificate.
Okay, because I called in the vital statistics, and they told me that me and Emily both had to go get the acknowledgement of parentage and have it re-signed and re-notarized, and not being able to find Emily, I don't see how that's going to work.
Okay, so I can get in touch with you and we can work on that. I can
All
help
right,
you
cool.
with that. But
Right
we
on.
do have to get mother served.
Yes. Yep, Ms. Farr.
Okay.
So what I'm going to do for both of you is we'll give some additional time for the parties to work with Ms. Farr, Ms. Curry on the service issue, Mr. Phelps on whether it's appropriate for you to be put on the birth certificate. Otherwise, you're essentially not a party to this particular action right now. So I'm going to grant additional time for that. Ms. Curry, because you are here and indicating a desire to continue with the emergency minor guardianship at this time, I will re-sign a new immediate emergency order pending resolution. How much time do you think we need on this case? A couple issues kind of bouncing around.
I would suggest we set this one for December 19th as well and see what, how far we can get between now and then.
Okay, was kind of my thought, but I know we're kind of stacking up the 19th, but will that work for Ms. Curry?
Yeah, that'll work.
Okay, and Mr. Phelps, since you're here, you're not quite yet a party to this case, but will that work for you?
Yes, yeah.
Okay, so log back in December 19th at 10:30 a.m. I will sign a new immediate emergency order. So Ms. Curry, if you need that, for healthcare or school records. That'll be available for you at the clerk's office after today. Okay,
Thank you. I appreciate
so I was looking through this case. I didn't see, but I'm gonna look again. You didn't file for an immediate. Well, maybe I'm just looking to see. Typically, I would have an immediate order. Not seeing it. Was this just a full petition filed?
Ex parte emergency minor guardianship. That's what my work says.
I believe it's number 7.
Oh, okay. Maybe I just didn't go to the right place. Okay. There it is. I was looking in the wrong place. Thank you for your patience on that.
No worries.
So, couple questions. One is, the parents you have listed in the petition number. So you have the mother listed as Lindsay German.
Yes, that's my spouse.
Okay. And then parent 2 is listed as unknown.
So I have a copy of Angelique's birth certificate, and that's got dad's information on it. I didn't have it with me at the time, but besides his name and date of birth that's listed here, I don't know anything about him.
Okay. So we will have to, because he is on the birth certificate, then we will need to make sure that he is added to this case, and he will need to be served.
Okay.
I also didn't see service on Lindsay. Have you served her?
I have everything ready to serve her. The problem is, I listed on my my ex parte application, or whatever it's called. I have a no contact order with Lindsay, a protection order against her.
Mm-hmm.
I was contacted by her family as well as the CPS office down in Del Norte County, California, to come get Angelique because she could not manage her care. She's critically ill and medically complex. And up until they left Washington State in July, she had nursing services. So her family couldn't care for her. And I believe my wife was going to lose custody of her. So I went down and got Angelique. The problem is I don't have anywhere to send the paperwork to be served. She is everywhere from Northern California down to Bakersfield, and her family doesn't even have an address for me to serve her at.
Okay. So that brings up a few more questions for me. Well, first of all, we have to get her served. So I'll appoint a court visitor likely, but I'm questioning jurisdiction. So, okay. I'm just looking to see what was put on the petition. So child has resided in Washington
Her entire life up until July.
Okay. And then how long was she in California?
From July 18th or 19th until we came back together from California on November 9th.
So she was in California July 18 or 19 through November 9th of this year?
Yes. I went by the courthouse there, and they said that because she wasn't in California more than 6 months, that it could all be filed up here. I mean, it was like the self-service law center, but I did stay down there for a few days with her to see what help I could get from them. And that's what they suggested to me.
And I think you did mark that on your petition that the child was not in Washington for a period of time in the last 6 months, but that was a temporary absence.
Yeah.
I guess the question I have is, you said CPS is involved. So are there any court actions that have been instituted in the state of California regarding this child?
My wife on November 3rd got a DUI for alcohol and drugs with I call her my daughter, our daughter in the car. And she got a willful cruelty to a child charge. And from what I understand from her family, that she has court in December regarding that.
Right, but I'm meaning, are there any court proceedings involving the child as far as in California, dependency, guardianship, another action like this, any sort of parentage action, anything like that, parenting plan that's occurred in a court in California regarding the child?
No, ma'am.
Okay. Okay, so here's what I'm going to do. I'm going to appoint a court visitor on your case with regard to service issues specifically. I also am hopeful to get either the court visitor or we do have a in-house courthouse investigator now. At some point, I may want them to do a search on what, if any, California cases may be out there involving this child. But for today's purposes, for the immediate emergency order, I will find that we have at least emergency jurisdiction over the child. I'll have to make that final determination before we approve any sort of formal guardianship with a little more investigation. But I'm going to find, at least because the child is back here, and other than the period of July to November, has resided in the state of Washington. And how old is the minor child?
She's 9.5.
9.5. Okay, so a significant majority of her life has been in the state of Washington. And given the unique circumstances where there could be potential harm to the child in California, for now, I'll base my order on emergency jurisdiction. I'll extend through the next court date. Ms. Farr, what is do you want me just to work with the judicial assistants on the next court visitor, or?
It would either be Tina or I.
Yeah.
I'm not sure who's up on the list. I know I haven't had a new case for a while, so might be me. And just listening to this too, if the petition also listed what the urgent medical matter is, then that also gives the court ability to put emergency order in.
Okay, great. Thanks.
She's critically ill. She has fatal medical conditions that require 24/7 care. So she's always had that in support in place until July.
Okay. Well, thank you for being there for her. I agree that that's an additional basis for the jurisdiction, at least for this immediate emergency order that we'll find. Ms. German, how this works is I will fill out an order assigning a court visitor to start working with you on the service issues so that we can move forward. You probably heard me talk about those in other cases. It's just a jurisdictional requirement. It will either be Ms. Farr, who's on docket today, or another court visitor named Ms. Day. One of the two will reach out to you to start working on those issues. I will sign a new emergency order through the date of our next hearing. Again, I'm probably going to propose December 19th. Will that date work for you?
For me? Yes.
Yes.
Sorry.
Oh, you're fine. Okay. So December 19th at 10:30 will be our next court date. I'll get the immediate emergency order extended through that date. If you need a copy of it, it'll be here at the clerk's office. And then we'll also get the court visitor order filled out and assign you a court visitor.
Okay. And that allows me to talk with her doctors, schedule her medical appointments, correct? Because I am like...
Yeah, so you didn't mark those on the initial order. So it didn't get signed as authorizing you to make healthcare decisions and school decisions and accessing healthcare records. But I am going to, especially based on what you've told me here today, I am going to go ahead and make those findings on this new order. So certainly come get a copy and then you can take that to the doctor's offices.
Okay. And school as well. She hasn't been in school at all this year. And she normally gets like speech therapy, occupational and physical therapy through her school.
Okay. There is a section I can also mark for school and educational decisions.
Thank you very much.
I'll mark all of those boxes.
Thank you.
Okay. Any questions for me?
Not really, not that I can think of right now.
Okay. Well, we'll see you back on December 19th and one of the court visitors will reach out to you shortly.
Okay. I appreciate your time. Thank you guys.
Yes. Thank you.
You're welcome.
Anything I have missed on this docket?
Okay. Since I see Ms. Schaefer on the docket too, I have a question if you don't mind.
Yes, absolutely.
Real quick. So we are utilizing Ms. Schaefer then to do investigations in the guardianship matters as well as family law?
I thought we were, but I guess maybe I should speak to the full bench before I say that out loud on docket, but that is my understanding eventually. I don't know where we're at in that process, but I think that is the case.
Okay.
Yeah. But
just asking for clarification. I thought it was for family law only. So,
I thought it was both, but let me triple check on that, and I can shoot both you and Ms. Day an email on what I find out.
Yeah, I missed the last brown bag, so I missed whatever information was shared and
Mr. Zandy
meeting
is
Ms. Schaefer,
present
so I wasn't
representing
sure.
petitioner.
Okay,
Okay,
thank you.
I am not going to try to pronounce this last name, so I'll let you do it first, Mr. Zandy.
Smolenka.
Okay, I'll just stick with what you said.
Yeah.
Okay, and then do we have the respondent, Jelena, present?
And she not participated much throughout this project. She's been in treatment. I have fought with her over the past several, which was somewhat a surprise, but at this point, there hasn't been a lot of activity. She did not participate in the GAL report. We haven't, as she hasn't formally done it. She appeared back in the spring for the original temporary order hearing. We did get the GAL report from Ms. Turnbull a week or two ago. The court also cited her to fast track this case to try to settlement. If I do hear from Ms. Smolenka, certainly that bodes well moving forward, and there's a chance we could resolve this case short of trial. Again, I'm not going to hold my breath on that.
Okay.
Anything to do today outside of attest to the fact that the GAL report has been published and a trial date is now looming.
Okay. I did see that GAL report had been this respondents. Let's see, someone is not muted, giving a lot of feedback for me. If your case is not actively being called, just go ahead and mute yourselves. Okay. I did also notice respondents' failure to meaningfully engage with the GAL process. So I think at this time, what we'll do for today's purposes is that the GAL report is filed. I do have the order waiving any sort of, I believe, mandatory settlement conference. So this will go on for trial assignment. Anything else, Mr. Zandy, we need to do? Great.
No, I don't think so.
So I have us on for, at least to the best of my understanding, 2 show cause contempt hearings. I have a motion hearing regarding the parenting plan, and also on for child support.
Generally, Your Honor, that's correct. I can give some say background. We were in front of the court, I think back in September, at least preliminarily, there were a series of dates pending. Ms. Olson had put the matter on with a docket notice to try and get a final parenting plan. No motion, and the requested relief was for a final parenting plan. That was addressed with the court, and the remaining dates were consolidated. My notes or recollection, we objected to the parenting plan modification because it wasn't properly before the court, and the court reserved on fees, but maybe wasn't clear whether it was the intention to move forward on that. Several weeks later, Ms. Olson did file a motion to modify the temporary parenting plan, but again, primarily requesting that a permanent parenting plan be entered. We did respond, don't believe it's appropriate to modify the parenting plan, but it's her motion. There's just a number of different things from both parties or all parties. We did also file an objection to her last declaration on October 30th that it should not be considered by the court. That was in the file when the matters were originally set over. The contempts, one by my client against Ms. Olson, one alleged by Ms. Olson against my client, I think both fundamentally address the tax exemption, and then child support. The parties agree child support needs to be set. There's just some issues on, I think maybe the date that it would begin or incomes. So I'll defer to Your Honor on how you want to proceed, but I guess think that's the general statement of what's in front of you today.
Okay. So it sounds like maybe let's start with, I believe then Ms. Olson's motion to amend the temporary parenting plan.
Right.
And I think a couple things, Ms. Olson, I will let you be heard here in just a minute. One of the things I did see was the October 30th declaration that you did file regarding the parenting plan, child support, and contempt. I will say it significantly is out of conformance with our rules. I know you're okay. I'm going to start muting folks. Ms. Olson, your declaration is significantly out of compliance with our local rules. I know you're proceeding without counsel. Have you had an opportunity to review the local rules in our court regarding page limitations and the like in family law matters?
No, I did not. I didn't read up on any rules, so that's, I apologize for that. The last page was just a signature. And then one before that was just a signature, and it was over 2, and they never objected to that. And I wasn't aware of there was, a number of times you could respond. I wasn't aware of that because the last 2 times they waited until Friday, and so I was only able to do it on that next Monday. So so they were saying, it was not timely, even though, it's been 2 weeks now. So I do apologize about the page limit, but I mean, there has been time to review it. And I do discuss the contempt in there. I was going off of the old final parenting plan because when I came up to the clerk to get all of our papers, they left out the temporary child support. And that's where the tax exemptions set. And so I tried to go back and get the contempt back from them like an hour later, and they said that it had already been filed. So I addressed that in the last declaration.
Okay. Well, I guess I am a little bit concerned when you tell the court you haven't taken the opportunity to review the local rules. Unfortunately, we still have to hold you to knowledge of the local rules, even though you are representing yourself. So I am going to strike your October 30th reply declaration. It is significantly out of compliance with our local rule requirements. I will not consider it for today's purposes. What I want to ask you first on your motion to modify the temporary parenting plan question that comes up for me, it sounds like one of the things you're significantly asking for is that it become that this court finalize a parenting plan. Is there something else you're asking for beyond that in your motion to modify the temporary parenting plan?
Well, our temporary one just says agreed upon by parties. There's no times, there's no anything. It's just whenever, now that the girls are a little bit older, they're 14 and 16. My oldest daughter is driving. I understand that they need to, be teenagers and be kids. But before she was driving, they were coming over to my house every weekend. And like the last 6 months or, since summertime, they come over maybe on Sunday afternoon for a couple hours. I just want them to, come to my house, and whether, I don't want it to be up to them. Like they can go to work from my house. They can go to their friend's house from my house. I just want to be able to hug them, and, FaceTime just isn't enough sometimes.
Okay.
So he does say that it's been working and yes, but not the last 6 to 8 months. He says that, there was the respondent says that they shouldn't have to come over and put in their time, like it's jail or something. And so I do realize, like I said, that they're growing up and, being teenagers and having friends and jobs and all that. But, they can, I just want more than, a few hours a week with my daughters. And he said it's been working, and it it not in the last some time. So
let me, Mr. Baldwin, your perspective on the the petitioner's motion to modify the temporary parenting plan.
Yes, Your Honor. So I maintain the same position when there was no motion. It's deficient in that the relief requested is finalizing a parenting plan that the court doesn't have the discretion to finalize at this particular point. With regard to the specific issues raised, if the court were to get to them, I do think my client's declarations establish sufficiently that there's no reason to modify what the temporary is. This is a peculiar, unique situation where a temporary order has been in effect since 2019. The parenting plan, it was entered on a temporary basis in December of 2019, gave custody of the party's son, who at the time was a minor and has since aged out, to mom, while my client had custody of the daughters, and the parenting plan language was the same for all children. the son was to have visitation with dad when agreed between the parents. The daughters have visitation with mom as agreed between the parents. It didn't become an issue to mom until the point came that the son aged out. And I think contemporaneous with all of this is the filings were made somewhat contemporaneous with being put on notice about a potential contempt related to mother taking the tax return of one of the daughters after my client instructed her not to because of the order of the court. So I don't think that there's any basis, even if the court were to consider the motion at this time, for the court to modify the temporary that has been in effect. And if the court does consider it on the merits that there's no justification or basis to make the modification at this point, if mom wants a final order, she can put the matter on for a settlement conference or trial, and it can get to the merits of the case ultimately. But this is the parenting plan that she had no issues with when she had the son, and now, for whatever reason, has become identified as an issue for her. So I think the motion is itself deficient, and even on the merits, there's no basis to modify the temporary order at this point with the information the court has.
Ms. Olson, anything else you want the court to know on this specific issue?
No, so Mr. Baldwin sent me a letter back in August saying, that, hey, sign our papers and, we're going to, charge you $560 a month in child support, yada, yada, yada. And, there's no, in the paperwork, there's no specific parenting time with my daughters. So I just wanted that to be, in writing somewhere that, I was able to, visit my daughters. Now, Mr. Olson and his lawyer, they want, over $1,000 in child support for me, but they don't want to let me have any visitation with my daughters, on paper.
So,
yeah.
So ma'am, what it does sound to me like, and I agree with the arguments of Mr. Olson's attorney, in essence, what you're asking us to do is bypass procedures for a contested trial, mandatory settlement conferences, those sorts of things, to get to a final parenting plan. So I am going to deny your motion to amend the temporary parenting plan. If you want to address those issues and have changes made. Oh, did she fall off?
No, I'm here.
Oh, you just turned off your camera. Okay. And that's fine. I've seen you. If you need to turn off your camera for bandwidth, you certainly keep it off. You need to set this for a contested trial. So that is going to be my ruling on the petitioner's motion to amend the temporary parenting plan. Let's go to child support. And I'm just looking, did we have temporary child support orders yet?
Yes, Your Honor, that's part of the issue. Is back in the modification in 2019, the court set a child support order that factored my client's income because he had greater income, even though he was the primary parent of 2 children. He ended up paying support to Miss Olson with a transfer payment at the time of $220 a month because of their son that was in her custody. When their son turned 18, because it was a temporary order, support enforcement wasn't able to assist in basically fixing the support obligation. The offsetting ended when their son turned 18, but Miss Olson was not and has not paid support for the daughters since that time. She did file the motion regarding setting child support, and it is accurate, Your Honor, as I had somewhat indicated. There was a letter as referenced by Miss Olson indicating some of these concerns in an effort to negotiate a resolution. It didn't result in one, it resulted in her motion, which is why we have all these other motions. We did file a child support worksheet based on her income. She indicated in her motion she makes $25 an hour. I don't recall that we had a pay stub or anything beyond that to factor the child support amounts. So we did run worksheets based on income and came to a transfer payment of $1,043. We are also asking the court set, not based on those numbers, I don't think it'd be appropriate. The order that was in effect from 2019 had income amounts that would result in transfer payment from Miss Olson to Mr. Olson for the daughters that remained in his care after their son turned 18. It's a little over 12 months worth of time that the court should order support retroactive from the amount in that order to any new order of the court, and that from the date of the effective new order based on our worksheet.
Okay. Ms. Olson, have you had a chance to review I see you have filed a motion to amend child support as well as the respondent. I only have the respondent's proposed worksheets in order here.
Well, I've turned it in a couple times, so it should be in there somewhere. I put an updated one into the last declaration that, you know, they wanted to strike. And since then, a couple weeks ago, I started a new job where I only make $20 an hour and I only get paid once a month at the end of every month. That's neither here nor there. $1,000 is just, that's just out of my means. Like, it's just, yeah. I mean, like I said, Mr. Olson makes 81 an hour, and now I make 20. And I have no problem paying support for my daughters. I just initiated that to, you know, show them that I don't have a problem. And, you know, I gave a list of all of the, you know, expenses that I've paid for them, you know, in the last, you know, few months. It was like $3,000. I just don't want him to continue telling people that I don't help. Yes, it's not deposited to his bank account or, you know, to a, you know, child support card, but I do help with my daughters, whatever they need within my means, like whenever they ask. I mean, they ask me for gas money. You know, our youngest daughter asks me for lunch money every day. I send that to her on Apple Cash. Literally, like I send her $10 like every other day for lunch. And it's $1,000 is just like, I can barely like get to the grocery store as it is.
Here's what I'm going to do on the child support issue. Because I did strike your October 30th by declaration, which includes at the end of it, your proposed child support worksheet. What I'd like you to do is to refile at the court rules to make sure that you're filing it in a way that the court will accept. And I'm going to set just the child support issue over 2 weeks if the parties are available. I believe is December 5th, if I'm not mistaken.
Okay.
And you know, I also think looking just at respondents' proposed child worksheets, I do think that's a large amount of money to request in a transfer payment given the discrepancies in income here. So I want to give you time, Ms. Olson, to properly respond. So would both of you be available on the child support issue December 5th at 1 o'clock?
I am, Your Honor.
Okay. And Ms. Olson?
Yes.
Okay. What I'm going to do, I know we have this short week this week. Could you get your reply declaration or a declaration with your proposed child support worksheets into the court and to Mr. Baldwin by next Tuesday, November 28th?
Yes.
Okay. I'm going to set that as your deadline for the financial information. Okay.
Okay. So I'm allowed to submit another declaration, even though they said that I've had too many.
Just on the child support issue, okay. I would like you to resubmit, but please read the local rules as it pertains to page length and that sort of thing. But I think it's a significant enough issue that can make or break people that I'm giving you the opportunity to respond just with your financial information, your proposed worksheet.
Okay.
Okay.
Thank you.
And then I think that leaves us with the contempt issues.
Yes, Your Honor. And it sounds like, I don't want to misspeak, that Miss Olson is basically, is she withdrawing her contempt?
Yes. Yes. Like I said, I tried to go get it back after I realized that, that I didn't have that temporary child support, you know, worksheet. And so they said that I couldn't get it back. So since I didn't call to check on it the next day, I didn't think that it would be heard or even seen or be approved.
Okay. So we can strike petitioner's contempt motion. Mr. Baldwin, it seems like what that leaves us with is, if I'm not mistaken, and again, I know I'm kind of coming into this 3/4 way down the case, it looks like it's your client's motion for contempt regarding who gets to take a tax credit here. Is that correct?
That's correct, Your Honor.
How does your client want to proceed on that issue today?
We're asking the court to make a finding of contempt and impose the requested attorney's fees and sanctions, as well as remedy. So our contempt is based on the tax credit, as the court can see, is identified in the parenting plan and child support order that was entered on a temporary basis in 2019. Miss Olson received their son, who lived with them or lived with her primarily, and my client received both daughters. That was the operation of things until the son turned 18. My client, in his declaration in support of the contempt and attached text messages, found out that Miss Olson, when he tried to file his tax return, was rejected. He became suspicious and concerned that she would have claimed one of the girls. She didn't respond. He continued to text. She ignored him. Ultimately, filed his taxes without both children as set in the court order. It's a unique situation where it's not as though the current order is an alternating year where the court can make up for it by allowing additional years of claiming the children to my client. So he filed his taxes, and as a result of that, basically lost out in the benefit. So we're asking the court to find her in contempt, attorney's fees for having to bring the contempt. It also is a peculiar situation, Your Honor. Miss Olson, in her declaration that was struck and in her presentation today, intended not to proceed on her contempt. We were in court more than once, and there was no direct withdrawal of the contempt, despite her claim that she went back to the clerks to try and rescind it. It was on the docket and on the record that both contempts were being addressed by the court, and so we had to prepare as though we were responding to her contempt, even though it was improper, and responding to all of this, even though significant portions of it didn't comport with the rules. At the very least, there should be attorney's fees as requested for the contempt. She herself identified in her prior recitation that she received notice via mail of a suggested resolution regarding this, and instead of negotiating or discussing, she filed to finalize the parenting plan and filed her own attempt to get a contempt against him for complying with the order she complied with for the prior 4 years. So we are asking the court to order her to amend her tax return, removing the exemption for their daughter Emma, so my client can refile with both exemptions pursuant to the order. That attorney's fees and civil sanctions are appropriate for, say, blatant disregard of the order that was in effect that she received at the time, and wasn't again an issue until their son was no longer eligible for her to claim, and she just unilaterally claimed one of the daughters without any legal authority to do so.
Okay. Ms. Olson, let me just ask you kind of pointedly, it appears that this is pretty black and white as far as you claimed an exemption for a dependent, when in fact that's not what the court order indicated. Is that correct?
Right. So like I said, I had gotten all the copies, and I thought that, I was allowed to claim them because I didn't have the, child support, the temporary child support worksheet. So we discussed it, and he said, okay, this better not happen again. And so then 6 months later, he, got the attorney. And so that was his choice to get the attorney. Like, I don't know why I should have to pay for his attorney's fees. He got it not because of the contempt. He got it to, try and get me to sign something that I didn't think was fair. So that's why I opened it. But yes, I did. We discussed it over the telephone. He said, this better not happen again. I mean, he got 10,000 instead of 12,000. Like that. Yeah. So yes, I did file, our old parenting plan said that we alternated, and Justin, you can't claim kids that are 17 or older. So I haven't been able to claim him for a couple of years in response to Mr. Baldwin.
Just a second. I'm just going back to that order. Give me just a second. What I'm going to find on that, and obviously taking into account the December 16, 2019 order of child support, which is very clear that every year Christopher Olson has the right to claim Emma and Elizabeth Olson. I will find that there was contempt by including in Ms. Olson's tax return. There's nothing in the record for me to find that it's not willful or intentional. I will find contempt on that matter. I'm going to, as far as sanctions for that contempt, I will order. I don't have an original order for contempt on this. I know it's been set over so many times that it probably was in the file at one point, but isn't any longer. So Mr. Baldwin, send over a new order.
Yes, Your Honor.
I can get that signed. I'm going to get back to your original request here. I'm going to order Ms. Olson that you refile your taxes, taking out that exemption so that Mr. Olson can have his return accepted if that has not been done already. I will include costs of 105. I will include a civil sanction of 105. I will, on attorney fees, the requested amount is $3,500. I'm going to reduce that to $1,500 in order that that be paid.
Okay, so 15 and then 105.
1,500 for attorney fees, 1,000 as a civil sanction, and 105 in costs.
Okay.
And I can present that to your honor along with just an order denying the motion to modify, just to keep things clean. If you'd like, I can send both of those to you, so we don't have to put on a presentation docket for you.
I think that would be great. I appreciate that. And then Ms. Olson, just for your records, when you all appear back on December 5th, the only issue that should be addressed at that time is the kind of dueling child support request. So please make sure to get your information filed again by next Tuesday.
Okay.
Okay. All right. Anything else on these matters? 0045108.
Okay. Thank you both.
Ms.
You're free to
Petrie
log out.
present representing her client, Joel Lowe. Do I have Amber Lowe present?
Yes, Your Honor.
And Ms. Powers, I see you there on the behalf of the state.
That's correct. Yes.
Okay. All right. Ms. Petrie, go ahead.
Thank you, Your Honor. This is our motion, and we are asking that for a number of items. We are asking that the court adopt our parenting plan, although we would like to modify that request with regard to the residential schedule. The parties since August have been doing a 50-50 week on, week off schedule, exchanging on Sundays at 5 p.m. And that seems to be working, and the children seem to be doing well under that schedule. So my client is asking that the court adopt that schedule as part of the parenting plan versus what the local rule schedule was that we put in there initially.
Ms. Lowe, are you in agreement with that change to the visitation schedule? Are you objecting to the proposal made?
Yes, Your Honor, I agree. That's the schedule that we've been maintaining since we agreed upon separation. And it seems to be the healthiest for the children and working out the best. So I agree with the petitioner's amendment to not go with their original parenting plan, but follow with the week on, week off that we've been doing since separation.
Okay. So, and I'm just going to make sure, and again, I know I'm kind of pinch hitting here, so I want to make sure right now we're still on motions for temporary orders, correct?
Yes, this is the first hearing on this case, Your Honor.
Oh, okay.
So we are also asking that my client wants to return to the family home, and I can get into that argument in a minute. We addressed in the motion our request regarding temporary use and possession of the vehicles and property in their current possession, payment of bills. I think that was it. And child support. She in her responsive pleadings requested spousal support, although she did not make a specific request as to an amount. Your Honor, as to the marital home, my client did not agree to moving out despite mom's assertions that he did. The text messages do not reflect that he was in agreement with this option, and in fact, he never agreed to any of it. She demanded he moved out. She barked orders. She told him exactly how it was going to be, and that's what he was stuck with, or at least he felt that he was stuck with. He has a separate property interest in the home from an inheritance that was constituted the down payment. And Your Honor, the fact is, it's my client who can afford the home. She can't afford to stay in the home on her own. She's not working, and that is by choice. And she has since moved her boyfriend in. This person that she claimed in her responsive declaration was only a friend, and whom now she is 5 months pregnant by. So her representation to the court that this individual was just a support friend and just a good friend, no, it wasn't, which validates my client's accounting of the facts in this case. The situation mom is currently in is of her own doing because of her choices. That does not relieve her of the responsibility now to support herself and to equally support her children. She expects my client to support her boyfriend, and their new child. And so where is her boyfriend's obligation? That's what we have to ask. Why should my client be paying for a house for him to live in rent free? He's not paying rent. And my client is not only the out spouse, but the expectations that she places on him in the text messages are untenable and unfair. She demands money. She demands gas in her car. She demands groceries. She demands diapers. He doesn't mind those things, but he is also paying for her housing. He's paying the utilities. And in fact, he believes that her boyfriend is working out of the marital home using the internet he's paying for. So my client is continuing to pay for the internet and the utilities to make sure that they're paid, and so his credit doesn't get affected, and to make sure his children are safe. But he is seriously being taken advantage of here. That being said, there's absolutely no reason she cannot be working. And as the court is aware, we just agreed to a 50-50 residential schedule. So that means that there's no reason she can't be working on her off weeks from the children. I'd like to point out for the court that she did not file a proposed parenting plan. She did not file a financial declaration. We have no idea what her expenses are, what her income is, if she has any. She needs to get a job. If her boyfriend isn't working, he needs to be. If he isn't working, then if he is working, then he needs to pay rent, thereby reducing my client's obligation. He can choose to pay rent to my client, or he can find his own place. My client is paying for everything right now and has been since this whole thing occurred, where she just picked up and left with no notice for a month and 3 weeks, and then just expects him to be out of the house, expects it to be in perfect shape, perfect condition upon her return. My client wanted me to address the flea situation and the messiness of the house. The house is not as messy as she tries to represent. And here this guy is trying to take care of these kids and take care of kittens that she initially brought in. She decided to foster a bunch of flea-ridden kittens, and she brought them in the house. The flea issue started because of her. And then she tried to blame it on him. And now she's trying to use this declaration and this court process to say that it's him, it's his fault, it's his neglect, which is not the case. She also made some serious allegations about sexual assault, and then talked to my client subsequently, wherein she informed him that, well, the last time they were together, she just didn't want to. Never once did she say no. Never once did she ask him to stop. She never yelled. She never screamed. She never cried. She never called the police. She never sought a restraining order. Even now, in response to our motion, she's not even seeking any kind of protection order or restraining order against my client. She has no fear. You can't consent to something and then turn around and claim it to be an assault just because it wasn't something you wanted at the time. If you didn't want it at the time, you need to speak up. You need to fight back. She didn't. So she can't come now to the court and say that my client is an abuser and that he sexually assaulted her. Not to mention the fact that it was not in the middle of a fight. It did not occur out of rage or extreme emotions. It just occurred. They're a married couple. As to requests for her spousal support, she makes no specific requests. She provides no financial documents. We have no idea what the status is of her boyfriend. And she is simply claiming that because they were married and during the marriage, she got to be the stay-at-home mom, she should continue to live that life of luxury just after it was her decision to end the marriage, and not have to support herself or equally support the children. So we are asking that our motion be granted, Your Honor.
Right. Ms. Lowe, I have also received your response. I did not receive a proposed parenting plan from you, but I have received your response to the petitioner's proposed parenting plan. What would you like the court to know?
Well, Your Honor, there's many discrepancies in the petitioner's responses. I would just like the court to know that we had a mutual agreement when I wanted to get divorced that he would move out of the house. There was abuse in the relationship. That's why I left the home, marital home, during the time so that he could move out and it was safe. So when I returned, I have text messages showing that he knew I was at the airport. I was on my way home. He was preparing one of the vehicles for me. And originally he had said I could live in the marital home for a year. And then after I got back, everything changed. I am also 2 months pregnant, not 5 months pregnant. In regards to the sexual assault, I did cry. I did say no. I don't feel like it's necessarily appropriate for court, especially with me with no counsel, but I can't afford counsel at this time. I've done everything in my ability so far of filing TANF and filing for child support. I have thrown out many suggestions to the petitioner, such as splitting the mortgage on the marital home or him not paying the mortgage at all and me just continuing to raise the children in the marital home. I've been a stay-at-home mom since the birth of both of our children. So for those reasons, that's why I asked to stay. And that was our agreement. And he was moved out when I came back. So
And
I'm sorry, Your Honor.
And you, there's another adult living in the house with you at this time?
There is. I don't receive any support through the state for my other child that lives in the home who's 10 from a previous marriage, relationship. And I don't receive any kind of support for my significant other, who I am pregnant with right now.
And is your significant other who's living in the marital house with you paying any of the expenses for the home?
No, Your Honor, but I have offered to start paying expenses in the home. I've never asked the petitioner to pay the mortgage. It was his conclusion that he was going to keep doing it. He said he didn't want the power to go out on the children. But my only request was to stay in the marital home and raise my children. I'm very flexible and everything else, but because this is a first hearing, we haven't gotten that far, and I can't afford counsel at this time. So I'm just kind of doing what I'm able to.
The period of time that you left Washington was about a month and a half, is that right?
Yes, Your Honor.
And the children stayed in the home with Mr. Lowe?
Yes, Your Honor.
So what I'm going to do, going through the petitioner's proposed temporary parenting plan, give you my ruling, and then Ms. Petrie, if you would be so kind as to make any changes per my order. I'll open it up for questions too. Jump in if anyone has questions as I go through this. So number one, in general, I'll adopt the petitioner's proposed plan with some changes. After review of the record, while I do think there is some evidence of probably more like 3B problems on mother's part, I am going to reserve for now on 3A and B limiting factors. We'll reserve those for the final order. Decision making at this time, for school, educational, healthcare will be joint. I will adopt dispute resolution and custodian section 6 and 7 as written. The parenting time schedule, I will adopt with the oral agreement that the parties have made here on the record today. That will include numbers 9 and 10 for summer schedule and holiday schedule. I don't see it directly in here, but I am going to order that Mr. Lowe remain in the marital home at this time. Do not believe it's appropriate for this court to order that Mr. Lowe pay expenses of this home while a new significant other is in the home. I also don't believe, without further investigation, that it's appropriate that the children at this time be expected to reside with a significant other that the court knows nothing about. So Mr. Lowe is to return to the home. Ms. Lowe is to vacate. Mr. Lowe will be responsible for payment of the, and I believe you had that listed in your original motion, all of the expenses related to the home. Yes, which includes the mortgage, utilities, insurance, property taxes, vehicle. All of that will be the responsibility of petitioner. As I understand it, this is a 5-year marriage. I'm not ordering support at this time. Excuse me, I'm not ordering any sort of alimony or marital payments to Ms. Lowe at this time in a temporary order. I'm going over to the temporary family law order that petitioner proposed. I'm just looking through to see, I believe it's mostly in accordance with exactly what I've already ruled on today. So I will adopt in its entirety then the temporary family law order, which does require that the petitioner or allow the petitioner to return to the home and stay in the family home. Respondent must move out of the family home within 30 days of today's date.
Your Honor, will the court address child support today?
I was just going to turn to you and ask the state if, based on my rulings on the temporary orders, if there were any changes to the state's proposals for child support.
There's not. The kids are receiving TANF benefits, and that I know that is a little more complicated because the statute prohibits a residential credit when the children are receiving TANF benefits. Our proposed worksheets were filed November 13th. We used the father's actual income based on his September 29th wage stub, which he filed with the court. The mother has no employment security history, so we imputed her at minimum wage 32 hours per week. I do note that that results in a transfer payment of $1,787 a month from father to essentially to the state of Washington, so long as mom remains on TANF. I do recognize, given your ruling, that may seem somewhat unequitable, but I'm not aware of an exception under the law, at least not in regards to a residential credit.
I do believe a residential credit would be appropriate, considering that they are going to be doing 50-50, and it is for 2 children. I also would request that she be imputed at 40 hours a week. There's absolutely no reason she can't work full time. My client certainly does, and he gets by.
And just briefly in reply, Your Honor, the statute, which I don't have in front of me right now, specifically says that a residential credit cannot be granted when a parent is receiving TANF. TANF is evidence that there's insufficient funds in the household to support the children. And then in terms of the mother's income, we followed the imputation statute, which indicates when there's no employment history and a parent is receiving TANF benefits, they're to be imputed at minimum wage 32 hours per week.
Here's what I'm going to do on this, because I don't have, I'm just looking through my papers diligently. Sometimes things get attached to the back of them.
We did not send over a proposed order. I was unsure where primary parent would land.
Understood. Let's do this because let's set this case to December 5 for presentation of the orders I've already ruled on, unless they get signed ahead of time. But it sounds like maybe if Ms. Petrie is arguing that there should be a residential credit, obviously the state's arguing the statute doesn't allow that. We'll set this on for a hearing as to child support on December 5th at 1 o'clock, along with presentation, if that has not already been signed.
Okay.
Okay.
And then certainly, Ms. Petrie, if you want to file briefing with the court, I'll give Judge Fassett a heads up that that issue's coming. But if you want to file any short briefing, feel free to do so. Any questions or clarifications on the temporary orders?
Yes, Your Honor. I would just ask that since the court is granting his petition to have me move within 30 days, given my circumstances of him leaving the home willingly and my pregnancy and having to relocate my other kids, including the ones I share with him, that at this time, I be given more than 30 days to find new residents. I know the petitioner had told me in person that he would extend it till January if it went this way, but I don't know what their feelings are on the matter.
What I'm going to do right now, and one of the reasons I'm making this ruling is I do think it's wholly inappropriate that for this court to have Mr. Lowe paying for household expenses when another adult is living in that marital house. So I am going to keep the 30 days right now. But if Ms. Petrie wants to, if her client wants to work with Ms. Lowe on an extension of that, we can certainly add that to the order. I have no issue with the parties going beyond 30 days. I wouldn't agree to anything less than 30 days. I do think that 30 days to move out is sufficient. But again, if Mr. Lowe wants to agree to longer, feel free to put that in the order. I have no problem signing that.
Okay. Thank you, Your Honor.
Any other questions?
No, Your Honor.
Okay, thank you all. If there's no other questions, you all are free by Ms. McLean, who is present, and Jason Moses, represented by Mr. Zandy. I also see Ms. Height present. Good afternoon, folks. This also is a case with quite the history. I have reviewed it. My understanding is that there are motions to amend orders.
That's correct, Judge. Both parties filed a motion. Mr. McLean and I have been in communication regarding these issues for the better part of the last 2 months. My client filed his motion, I believe, on November 3rd, and we got Ms. Moses' counter motion a day or so later. So I don't know who you want to hear from first, but I think both sides are prepared to make argument.
Okay, so let me just ask before we get started, because I think it kind of pertains to the case in total. Has Mr. Moses undergone any of the treatment that was ordered by the court eons ago?
Yes, he's doing that. So you saw a copy of the report from Dr. Johnson subsequent to that and after that. He gives you in his declaration the services that he's been seeking out, that being a certified sex addiction therapist. Tyler Chinchin has also worked with the Integrity Group. And then most currently he is working with Ms. Lovely. So on further evaluation. So not much more from our perspective he can do. That remains in process. I did speak with Ms. Lovely a week or two ago about that. She informs that she's ready to go working on that, has been a little bit behind in things. Not pertaining to Jason, but I think like most therapists is quite busy and inundated right now, was I believe what she stated to me. So he's working the process. He's doing what he can. Yeah, pending more information.
Okay.
So if I could just
go ahead
on that. So first off, I'm not aware of Mr. Moses participating in a psychological evaluation. I'm not aware that Ms. Lovely, who I think is a master's level practitioner, is qualified to do a psychological evaluation. This is the first I've heard that he's ever reached out to her. We have a court order that indicated that the prior evaluation with Dr. Johnson did not address the issues that the court had ordered him to address. And for the first time in Mr. Moses's reply declaration, we're told that he has been meeting with this Mr. Chinchin and somebody else for over a year and a half, information that was not disclosed to the guardian ad litem, information that's not been disclosed to us. We have received absolutely nothing.
Okay. So let's do this. And I know Ms. Height, I'm sure you have some input here.
I did file a brief reply. Did Your Honor have a chance to see that?
Just a sec. Hold on. I have a judicial assistant here, and then I will get right back to you. That case.
I filed some information for the court on the 15th, and I did a
yep
copy as well. My thoughts and conclusions are in there. I did not know about any further treatment that Mr. Moses was seeking at the time that he and I talked. And I do know that he has had a history of working on this problem over time, but I don't know of anything freshly that's been mentioned today as far as treatment goes.
Okay. So let's do this. I think because if I recall correctly, Mr. Moses's motion was filed first, and then Ms. Moses filed her motion. Let's hear from respondent first.
Okay. And thank you, Your Honors. The court is aware I do represent the moving party to the first motion in front of you, namely Jason Moses. And again, from a timing element, I seem to point out my client does file his motion, makes various requests contained therein. And I would say they're relatively minor, the relative tweaks to the existing order, which has been in place for some time. There's been no issues with the kids, contrary to what Ms. Moses parlayed in front of the court in anticipation of this hearing. My client details for you his time with the boys has gone exceptionally well. Both kids, that's Braxton and Lincoln, and I know you're going to hear conflicting information from Ms. McLean on that. My client details for you, once Lincoln is in the car with him, things are well. I would certainly start by noting that this is unfortunately a case, and I think your take on this was correct, that has been bogged down somewhat with evaluations, with treatment options, with allegations. We now have the new one that mom raised a couple of weeks ago in her submissions, all of which are aimed to curtail my client's relationship with these boys. And again, throughout history, my client has been very involved with these kids. These kids love their dad. Their dad loves them. He takes very good care of them. And despite the allegations of mom from this pornography addiction from 8 years ago or so, a lot of that, again, has somewhat come out through the GAL investigation, the report from Dr. Johnson, the evaluations of the ongoing treatment that my client has undergone. And again, you asked an important question at the onset. Now, what's he currently doing now? I don't know that he's ever stopped with a lot of his treatment. I think this is constantly something that he's been working on. He's taken accountability for that. If you went back to the initial stages of this case, again, you'll see he's never shied away from that. This is something that has been addressed. And this is something that Ms. Moses, again, continues to harken back to time and time again as a related issue. And since the separation, it hasn't been a problem. That's first and foremost. We look at where we're at now. You have obvious attempts of one parent who was trying to alienate the other. I think if we look at the facts of this and the timeline, again, my client files his motion in early November. All of a sudden, the allegations and his problems from Ms. Moses rise from, well, he's got pornography issues, to now he's inappropriately touching one of our children, the younger child, in a public setting at a soccer game in front of 250 people at 7th Avenue Park, which is directly observed from grandma and a babysitter that nobody does anything about. Nobody relays that to the authorities. Nobody raises that to their attorney. We don't find out about it again until we get her responsive pleadings. And then all of a sudden, it's this major issue. I think it's absolutely deplorable to make that allegation without any kind of substance to that, to just say, well, Jason has now filed as a father who wants very basic request to increase time. I'm now going to raise the stakes, up the ante a little bit, and claim that he is somehow molesting or inappropriately touching our child at a soccer game in front of 250 people in purview of grandma and babysitter, which again are strictly aligned with mom, who filed declarations 3 weeks later and say, well, we essentially didn't really know what to do, but conveniently here on the verge of litigation, here you go. I think he was inappropriately touching the child. Again, given the context of this, and given the history of this case, given the obvious attempts, which can only be classified as alienation, given the obvious attempts of mom to disrupt the relationship between dad and the boys, and she's done a very good job of that so far, she now again pushes all of her chips in and says, well, now not only does he have pornography issues that extend for years past, but he's also a danger to the children. That's problematic. And fortunately, that is kind of the tone and the tenor of this case. It has been from the onset, but my client was very surprised to review that. He was disheartened to review that. And again, when you look at it from the context of these kids, what is mom putting the kids through on this? I'll get to that in a moment. We look at my client's specific request related to midweek visits. Again, this is a pretty standard parenting plan. This is one where my client enjoys the children every other weekend. Also has a midweek visit, which traditionally has been on Wednesday for several hours, so from 4 o'clock to about 6:30. Oftentimes during those visits, and it's been every week, oftentimes in those visits, it involves going to soccer games and extracurricular sporting events for these kids. That's great. My client has done that. But while he's on the sideline watching the kids, which he loves to do, it does take away from his time with the children. Most recently, and again, leading to the filing of this motion, it was reviewed, and somehow in the order that was entered about this time last year, that Wednesday visit was not included therein. Parties continued to exercise that Wednesday visit. So my client had contact with both children every single Wednesday, but somehow through a scrivener's error or through some unforeseen circumstance, nonetheless, the order wasn't reflected as that. My clients had them every Wednesday. It was by agreement of the parties. Most recently, mom becomes aware of that and says, well, the order says you don't get every Wednesday, and therefore I'm taking one of those away. So the request today is this. So we are asking that you order specifically one of two things. Number one, that my client have 2 midweek visits every Tuesday and Thursday. Basis for that request is the fact that, again, these kids are involved in extracurricular activities. My client would like to attend their games, which he does, would like to attend and have activities with them outside of sports in the soccer fields, which is why we're asking that you modify that and bump that a couple hours a week, make it 2 times per week as opposed to 1 every other week. Alternatively, we're asking that you, if the court doesn't want to make that jump, especially given the most recent allegation, we're asking that you recognize the agreement of these parties, the status quo that has been in effect for the past year, that my client have every Wednesday with these boys from 4 o'clock until 7. That will give him an extra half an hour. That will allow him to take the boys to the park or take them to dinner, and again, maintain that relationship. As I mentioned in my prior comments, and again, this goes back to and dovetails with some of these alienation type behaviors. It's interesting that my client details for you in his initial declaration the fact that when it's, quote unquote, not his Wednesday, and he goes to the soccer field or he goes to participate in one of these functions with the boys, what does the mother do? Mom tells the other child, go sit with grandma and grandpa. It's not daddy's time. You hang out with them. And it strictly informs my client it's not your time. Essentially go stand by yourself and watch whatever the participating child is from a distance. Again, that is a sign of major control issues. We also have this issue, which my client details for you, related to the Great Wolf Lodge and the birthday parties. Again, my client plans a surprise trip to Great Wolf Lodge for these boys, has confirmed that's set to go, starts getting messages from Mrs. Moses saying, well, the boys need to go to a friend's birthday party on a Saturday afternoon, I believe it was. Starts putting pressure on him for that. My client says he's had other plans. Again, it's his time under the parenting plan. And what does mom do? Mom directly involves the children, telling them, dad won't let you go. Take it up with your dad. Kids end up going to Great Wolf Lodge. They have a great time. It all works out good. But again, this is further evidence of what type of situation and conflict we're having with mom at home and these kids. This is now showing itself. And the second request is that we change the exchange location provision currently. It parlays itself in these exchanges. Everybody agrees Lincoln is torn at these exchanges. This child, again, is working with Ms. Rosen. These parties are participating in some capacity with the family counseling with Ms. Rosen. But what do we see? We have mom who says Lincoln doesn't want to go with dad. Now, Lincoln is reluctant to go with dad. He doesn't want to get out of the car. My client readily confirms that. He says there's clearly some kind of a loyalty divide. Lincoln, who again is a pleaser, doesn't want to upset mom. Lincoln is now being, unfortunately, and it's a terrible analogy, but in a tug of war with loving both parents. Both parents love him, but he wants to please both parents, and that's at odds with the circumstances. Lincoln eventually gets in my client's car, and for the weekend, he's great. There are no issues. Again, there's nothing in the counseling records. I'll let Ms. Height speak specifically to that. I don't see anything in her report that suggests Lincoln is in any way in harm or in distress with dad. In fact, the information is contrary to that. What does my client tell you? There are no issues with it, and Lincoln is good. Braxton is good. What does Braxton do? He asks his dad. He says, Daddy, how many days until I get to see you again? That is not information from a child. And again, I would object to the child hearsay that's permeates throughout Mrs. Moses's declaration. That is not the communication from a child who is showing distress. That's the communication of a child who wants to spend more time with dad because the child misses dad and loves dad, just in the same capacity as the child misses and loves mom. And that's a good thing. The unfortunate thing we have right now is the children are, again, in the midst of this conflict between the parents and feel a loyalty, at least one of them, to mother, and mother is not helping that situation by, again, putting them in that circumstance, and the latest allegation doesn't help. That's what we're asking for in regards to the exchange location, simply that it be changed from a neutral site to door. Again, the parents can get the kids out, exchange the parents. I think that makes sense. Now, that's our second request. Third, and it sounds like it's agreed, related to this family counseling, as I noted, parties are participating with Charlotte Rosen. It sounds like that is obviously happening. There's been some hiccups along the way. Both sides attribute blame to the other. Nonetheless, where we are today is it's going well, and we continue to work through that process, and that's a positive thing. Simply asking that be reduced to order, and that both parties be required to participate in good faith and comply with the recommendations set forth by Ms. Rosen. Finally, and the last request is related to the holiday schedule. My client, since separating, has had very little holiday time with these boys. These boys love their extended family, love their time with dad, as I've noted. My client should be in a position to have extended time with these boys. That's what we're suggesting. He hasn't enjoyed Thanksgiving with them, to the best of my knowledge, in some time. We are asking that he have this year from 10 a.m. On Thursday until 5 p.m. the following day. That gives him the opportunity to start new traditions. And again, that's healthy and it's appropriate, and it's certainly reasonable based on the history of this case. Also asking for some time over the winter break. My client is off the entire winter break, as he is a school teacher, and we're not asking to impinge on mom's time. Mom has her own traditions, and again, those are very valuable for the boys. What we're suggesting is simply an extended visit from December 26th at 10 a.m. until December 31st at 6 a.m. Kind of gives him some substance in between Christmas and New Year's, gives mom the benefit of having both Christmas Eve and Christmas Day and New Year's Day. And again, best interests of the kids, that certainly gels with the theory that they should enjoy both time with both mom and dad over the holidays. I get into this, and I will very briefly, because again, in an effort to save time. This unfortunate incident at the soccer field, again, it goes unreported for 3 weeks, seems highly unlikely that a grandparent or a third party or one of the approximate 250 people that are in attendance would not have stepped in for the well-being of this little boy if they thought something was happening. They wouldn't have addressed it. Again, this is my client's ex-mother-in-law, would not go over to him and say, you know, I think that's inappropriate what you're doing with Lincoln. What more than likely happened from that? And again, we don't hear anything of it from 3 weeks later. My client gives you an explanation. I think certainly given the circumstances, it's likely, if not entirely, how that occurred. He sees his child, as he's done time and time again, even during the marriage, gives him a hug, gives him a little bit of a tickle on the ribs or the chest. Child is playful with dad. Child, again, as kids do, slap back, smile on his face the entire time. Child is put down. Child goes about playing with other kids. Nobody says anything to my client. And then 3 weeks later, again, barely one day after we file this motion and it's served on Ms. Moses, we get the allegation again that this case has now gone, unfortunately, nuclear. There's one thing worse than a child molester. It's somebody who accuses somebody else of molesting a child knowing they didn't do it. And again, given the facts of this case, given the circumstances that there being 200 plus witnesses at a soccer field to allege that my client, and this is where the Dr. Johnson report comes into play, where he says this man is of absolutely no danger to children, his or anybody else. To make that allegation, again, and the timeline and the circumstances it was, shows somebody who just desperately wants to maintain control of the family, somebody who has an axe to grind with their ex-husband, and unfortunately, that's the circumstance we're in now. So no wonder, given these allegations, no wonder, given this conflict, we have 2 kids, at least one of which is having significant issue getting out of the car and going back and forth. And that's the saddest part of this case. We need to stop treating my client like he's some kind of a danger to his kids, because if anything, he's the direct opposite of that. He's always been supportive. He's always been loving. He's always been nurturing. And there's absolutely nothing in the court record outside of his own admission that years ago he had an addiction to pornography, which again, I would argue, I still don't know what the impact on his kids is with that, that we are now riding this far now with the mushrooming allegations of that he's molesting or inappropriately touching his own kids. And that's a tragedy. It needs to stop. So we are asking you to grant the relief that we've requested, are asking again that the court make certain findings that is in the best interest of the kid and continue with the counseling. Everybody needs to do that. It's good for the kids. We'll get input when that time comes. But as for now, everything requested is reasonable. We're asking you to grant it in its entirety.
Thank you, Mr. Zandy. Okay, Ms. McLean.
Thank you very much. So we have filed a motion outlining the concerns that we have and requesting that visitation be reduced. Contrary to counsel's argument, he and I had a discussion about what the issues were, and that was memorialized in the email that was attached to my client's declarations. It was agreed that we would get motions filed without order shortening time that we would set for today. So I guess let me start off first with the concerns as it relates to our request on limiting his visitation. Lincoln, the youngest child, is clearly reacting negatively on transportations for visits, in counseling, and just is overall, he's deteriorated. There is something that has happened in August to cause a substantial change in him. And it's not appropriate for parents to physically force a child to go on visitation. And to be quite honest, that places my client in a bad position of not being viewed as a safe person when she's the one that's having to physically get him out of her car. Mr. Moses is physically pulling this child off of her in an effort to get him to go. My client has been supportive of getting these boys to go. She's been there for visitations. She's here asking the court to recognize that there is something seriously wrong with this 6-year-old child. If you go back and look at the history of this case, Mr. Moses was ordered to participate in a psychological evaluation to address his sexual pornography addiction. He has never complied under the temporary parenting plan with that order that was entered over a year and a half ago. He says that, the parenting plan specifically indicates that his failure to comply with the evaluations and treatment is a basis for Ms. Moses to ask for a reduction in his visitation time. You have 2 children who have been in counseling with Charlotte Rosen, who's a very well-respected practitioner in our community. These children have been in counseling with Ms. Rosen, not for a couple of months, as suggested by Mr. Moses, but for nearly 2 years that these children have been in counseling. That's a protracted period of time. And there have been ongoing concerns, and these were outlined through Ms. Rosen, through Ms. Height, as well as Ms. Rosen with counsel and I. The children, after these parties separated, started talking about a penis monster. The children, after these parties separated, started engaging in inappropriate self-gratification in public locations that even Ms. Rosen identified was inappropriate for them at their given ages. Now we have Lincoln negatively reacting to the visitations with Mr. Moses. And if you look at Ms. Rosen's email that we attached to my client's reply declaration that was sent out to both of these parties on November 8th, she says specifically that Lincoln has been, or that he's physically regressed, he's emotionally overwhelmed, and he's struggling to express his feelings. That does not align with Mr. Moses's claim that everything's hunky-dory at his home. We have Ms. Rosen, who has recommended child-directed phone calls. In other words, when the children ask to call, that then they should be allowed to call the other parent, and to stop the parent-directed phone calls. Ms. Height's report that was filed in January of this year recommended child-focused phone calls, that the parent-directed phone calls were not serving the children well and not serving these parties well. Counsel and I have been in protracted attempts for the last 4 months to try and resolve that issue alone without success. You have Charlotte recommending that these parents participate in co-parent counseling, not family counseling. Mr. Moses is suggesting that he's willing to participate in family counseling with the children. That is not what Ms. Rosen is recommending. And even Ms. Height in her recommendation talked about Ms. Rosen's willingness to engage these parties in co-parent counseling. Again, for the last 4 months, we've attempted to try and get that entered so that we could have some teeth to get Mr. Moses to participate in that. He has not been willing to agree, and even today is not willing to agree, even though Ms. Rosen has recommended it as being in the best interest of the children, and Ms. Height has recommended that it would be in the best interest of the children. Ms. Rosen has recommended that screen time be eliminated altogether during Mr. Moses's time. And that is because of his lax rules and his normalization of the use of screen time during his residential time. Obviously, when you're talking about somebody who has a pornography addiction, prior instance where the children actually accessed his pornography on, it was either the television or the computer during his residential time, that is something that we need to protect these children from. Ms. Rosen has expressed concerns over Mr. Moses's lack of honesty with her, his minimization of his addiction, the letter that he wrote to the boys before these parties started this litigation, where he acknowledged himself that he is a danger to his children and told his wife that if he relapsed, that she needed to withhold the children from him because he is a danger. That's his educated statement of his own addiction, that he recognizes he's a danger to his children. And you also have information about, again, because of this co-parent counseling recommendation, of how poorly he treats Ms. Moses in front of the children. Totally contrary to the narrative that they're attempting to spin. This is not a healthy parent-child relationship, and he has done nothing, absolutely nothing. You have nothing in written declarations from practitioners, in evaluations, in class participation. There is not one shred of physical documentary evidence and no disclosures to Ms. Rosen or to Ms. Height that he's participated in any type of counseling. And when you go back and look at his prior declarations that have been submitted with the court, he denies. He even told Ms. Height that he automatically quit looking at pornography. And even in her guardian ad litem report and recommendation, she says that's highly unlikely that he is able to stop cold turkey when he has not been able to be successful after historical repeated treatments and interventions. Mr. Moses is a self-declared 30-year pornography addict. Ms. Height outlines in her guardian ad litem report for you about the, and this sort of dovetails into Mr. Zandy's argument that he has no idea what this has to do with the negative impact on his children. Ms. Height sets it out. She says, available credible research shows that the viewing of pornography, whether one considers it an addiction, compulsion, or an innocent pastime, creates anatomical and pathological changes in the brain, which results in various manifestations of cerebral dysfunction, collectively labeled hypofrontal syndrome. In its simplest terms, it creates damage to the braking system of the brain, allowing riskier behavior while in search of repeated pleasure. This is an individual who, according to the witnesses that Ms. Height believed their credibility when she talked to them about what they observed, said that he put his hand under this child's coat, touched him, or basically kneaded his hand or palm into the groin area of this child or the lower belly of this child. The child's reaction was not to laugh. The child's reaction was startled. The child grabbed his arm, didn't push it away as he suggests. And now you have Mr. Moses saying that, well, I came up to him, I tickled his rib cage. That's a significant difference for him to say rib cage versus the lower groin area. Couple that with the good touch, bad touch discussion that Ms. Moses engaged in with the child when he disclosed that his dad does touch him between his belly button and his penis. You have multiple examples that my client outlined in her declaration of Mr. Moses talking out of both sides of his mouth and making contrary statements to Dr. Johnson versus what he's told this court. You have Commissioner Cotterell, who basically in open court chastised Mr. Moses for not being honest with this court, for being cavalier about his sexual addiction. And at that time, Commissioner Cotterell denied Mr. Moses's request to allow for holiday time or extended residential time. You have Ms. Height's guardian ad litem report in January that says maintain the status quo, no extended time. And again, her recommendation is this alternating Wednesday, essentially, not every Wednesday. For counsel to suggest that there's a Scrivener's error, I'm sorry, Mr. Zandy's been practicing for a long time. He knows exactly how to file objections with the court on orders. We've had multiple discussions about the fact that, yes, the parties have mistakenly been exercising or allowing Mr. Moses to exercise every Wednesday when the plain language of the order was that his Wednesdays were supposed to be after his weekends, which essentially is every other. To suggest that that's a Scrivener's error, he hasn't filed a motion on that. They haven't filed a motion for revision on Commissioner Cotterell's denial of holiday time or finding that he has not complied and that Dr. Johnson's evaluation does not comply with this court order. You have an individual who's basically skating. He's skating under the requirements of this court. He's come before this court and asked for additional time. And you have this child counselor for Lincoln saying this child is presenting horribly. And so much so that I'm now going to double up his counseling. Mr. Moses is not being honest with this court. We are asking that the court reduce his visitation time. We're asking that the court provide for the alternating Wednesday visits, that the court provide for the first, third, and fifth weekends defined by Fridays on Saturdays from 10 a.m. to 6 p.m. We're asking that the court deny any extended holiday residential time. We're asking that the court remove the parent-directed phone calls and go to the child-directed phone calls that were recommended by Ms. Rosen and recommended by Ms. Height. We're asking the court to order Mr. Moses to participate in the co-parent counseling that is recommended by Ms. Rosen and recommended by Ms. Height. We're asking the court to maintain the visitation exchanges at the Shell station in Castle Rock. My client does not want him at the house. She does not want to go to his house. They've been, by agreement, exchanging at the Shell that's equidistant between their residents. I'm not sure how you fashion that, he needs to allow for these children to participate in peer functions. The argument is that, well, he goes to the soccer games on Wednesdays, but that interferes with his visitation time. I'm sorry, I thought part of parenting was exposing your children to events and showing them that you're supporting them in those events. It's not what is the gratification that you're going to get on one-on-one time. It is supporting your child. That's what parents do. We're asking the court to enter an order to stop all screen time during his residential time. Counsel says that once, and I'm just going to go down my notes that I was taking while Mr. Zandy was making his arguments. He says that once Lincoln's in the car, things are going well. Again, that's not supported by how Lincoln's presenting in counseling. That's not supported by the concerns that Braxton has raised and what he's indicated.
Again, we're getting way, I've let it go. We're getting way far afield of what's in the declarations, and there's obviously child hearsay that's trying to be admitted once again. So I'd object to on both those bases.
Yeah.
And I would,
I'm going to sustain that. I think we are getting a little bit far outside the declarations because some of these requests are a little surprising to me. I do have the declarations and the proposed parenting plans in front of me. So, Ms. McLean, what are the final requests? And then I'm going to move on to Ms. Height.
we've provided those requests.
Okay, thank you. Ms. Height, and I understand that you did submit the November 15th report after review specifically of this alleged incident between father and son. I have read your recommendation. There are several recommendations in there that you're offering to the parties, but in essence, I take your opinion to be that maintaining status quo for the time being is in the child's best interest. But I'll turn it over to you to elaborate on that.
That, Your Honor, is where I landed. After speaking with Miss Rosen, I kind of deferred to her concerns. They were quite dramatic, and I felt like we needed more information from her before some other action was taken. I believe there's a lot going on. I would also like Your Honor to know that when I spoke with these parties, both were cooperative, both obviously care for these boys and want what's best for them. There's a big disparity, but that is one thing that is obvious from my conversations with both of them. When I spoke with the witnesses to the event at the soccer field, both were very sincere. I believe that the reports they made were in good faith. I don't think there was anything manipulative or nefarious about what they were reporting to me. However, I was unable to come to an agreement that that is what happened, mostly due to the fact that it seemed unlikely, as I put in my report. If I believed that there was molesting going on to those children, frankly, Your Honor, I would have requested supervised visitation. I think it is, if that is occurring and it is occurring in public, it's of such a concern that I wouldn't be comfortable otherwise. I feel like there's some difference between what was told me by both parties, and I could not come to an agreement in my own mind beyond that. So I don't like to be left there, but there basically was a he said, she said. I couldn't rewind the tape and watch it for myself, as there's no tape. So in addition to that, I would not characterize what's going on with the boys, particularly with Lincoln, as a hiccup. I think that there's something that is quite troubling. And I believe also, it hasn't been brought up here, but I think that Braxton is struggling as well. I think his struggles come out differently. Several people reported to me, including Miss Rosen, that Braxton's way of dealing with things is to close himself off with a book, and that he's doing that more and more. So my concern is for Lincoln. My concern is also for Braxton. And I think until we can figure out what is at the basis of that, I just could not get to a comfortable place to recommend any changes. I am specifically troubled by the idea of them having twice as many exchanges. I think doing this twice a week on Tuesday and Thursday is a recipe for just more distress at the present time until what's really going on can be figured out. So basically, I'm stepping away, wringing my hands, wishing that I had more information for the court. But in good conscience, that's where I could land, Your Honor.
May I ask a question?
Go ahead.
Ms. Height. So when you say status quo and going back to your final GAL report, what is your position on Wednesdays? As you know, they've been exercising every Wednesday. Your recommendation, and technically the temporary order, was for essentially alternating Wednesdays or the Wednesdays after his weekend visits. What is your recommendation on Wednesday?
I did not realize they were every Wednesday until very recently. So my idea of status quo is every other Wednesday at this time.
Yeah, I guess my point to that, or counter question, would be if there's issues with the phone calls, and again, if that's a complete swearing match as to what's going on with those, wouldn't the addition of an extra Wednesday take away the phone call problems that we're currently experiencing? So it could theoretically be beneficial.
I'm sorry, are you addressing me, Mr. Zandy?
If you've got a good answer for that, absolutely. Yeah, yes. I was intending for you to answer that, because the phone calls have been an issue. I think we all agree to that. If we allow another midweek visit, as they've been doing for the better part of a year, does that in any way impact the negative impact of a phone visit, or some of those, does it alleviate some of those concerns?
Well, nobody is going to appreciate my answer. I don't know. I'm not a big fan of tying kids into a scheduled visit at this age, a phone visit. I just think they're a little bit invasive, and when the kids can make a phone call at their convenience and tell mom or dad something happy that happened, I'm all in favor of that. I just think that when they are legislated, it makes it tougher on everyone, including the kids.
Get extra visitation in person with dad and the boys would be more beneficial than the phone calls.
I'm not prepared to answer that. I don't know.
Okay, fair enough. Thank you.
Thank you. Okay, Mr. Zandy, any short additional reply you want to make?
Yeah, and I'm going to rest largely on my client's reply because there is an answer to almost all of that. I will take the easy ones, which, and again, you got kind of the hint that I was making with Miss Height. I think if we give my client the one-on-one time with both the boys, again, Braxton, who wants to do that, I think that's beneficial. We can then take away some of those phone calls, which have been problematic for the last several months. That's first and foremost. I would also point out again, and whether these witnesses are credible or not, they are biased. They strictly align with mother. I would hope that if we walked into a grocery store, we were at a soccer game and we saw a 6-year-old with some grown man's hands in his pants and his groin tickling him, somebody out of 250 people that were witnessing that, especially a grandparent and a babysitter, would step in and say, hey, that's inappropriate. So if we look at that logically or reasonably, you're not going to sit around and wait for 3 weeks and say, we really didn't know what to do. And oh, by the way, there's a pending motion that was just filed yesterday. So now let's bring that allegation forward. That just flies in the sense of reason. So that's kind of where we're at. And counsel is very quick to appoint blame for Lincoln on my client. That's been kind of the theory and of their case from the onset, and somehow it relates to this porn addiction from years ago. The letter she cites is from years ago. That's when my client was trying to salvage the marriage and they were still in a relationship. So again, the weight of that letter should be given what it's worth, which is very, very little. And my client, again, has addressed that in prior hearings. So looking at the information from Ms. Rosen, looking at the information from Ms. Height, I think it's fair to assume, and the one thing we agree to is, yes, Lincoln is struggling at the exchanges right now. What we don't agree to is what is the root cause of that. And we don't know at this point. And again, my client gives you his position on that. It's logically and reasonably based. Mrs. Moses gives you her impression of that. And again, I think that doesn't hold a lot of water when we're looking at the circumstances of this matter. But again, these boys need both parents. I think it's obvious both parents love these kids. They have diametrically opposed positions and views related to that. I think everybody wants to work together to make sure that those kids' interests are being fostered. And that's what we need to strive towards. Instead of having allegations of mud being thrown, especially in the nuclear capacity as we're currently facing, we do need to go to counseling. I'm confused by counsel's suggestion that my client is unwilling to do that, when that is the very request that is in my client's initial motion that they responded to. So yes, let's pursue the family counseling, the co-parenting counseling, whatever you want to call it. My client, Jason, nod your head or shake your head. Are you on board with that? He's on board with that as suggested in our motion. So as far as going back and forth with this, again, we're spending a lot of time and effort and pointing fingers when what we need to do is figure out what these boys need and work to accommodate that. That's where we are. That's what needs to happen. And making the allegation that one parent who is involved in loving and nurtures and cares for these kids put his hand under the little boy's pants at a soccer game is completely inappropriate. And that flies in the face of what we should be trying to accomplish right now. Okay.
All right. Thank you to both counsels. Thank you to both parties for being present. Ms. Height, thank you for your input and report. I am going to rule as follows. And the basis for my ruling is rooted in, I think, what both parties have acknowledged on some level is, I don't think now is the time. Well, I know now is not the time for massive change in what is currently happening. And I mean that in a sense of, I understand there's an order hanging out there that could be or is construed to mean that visitation should be every other Wednesday. But in reality, what these boys have been experiencing and what the parties have acquiesced to for quite some time is visitation with father every Wednesday. So I would like that memorialized in an order, that visitation with father is to continue occurring every Wednesday. Again, every decision I make here today is going to be rooted in, now is not the time for major change for these boys. I don't believe that I have enough evidence in front of me to say that the allegations of some sort of abuse of one boy has occurred. More likely than not. I don't have any CPS documentation. There's no police involvement. I tend to agree with, I think, what's in Ms. Height's report, that I guess I would be shocked to believe something like this would be occurring in broad daylight in a scenario where there's been no concerns raised at any time during the pendency of this action that, yes, there might have been discussion previously of porn addiction. That's a very separate and distinct thing from touching your own children. So I don't put weight in that. I'm not making any changes to the parenting plan based on that. I do have to, however, take into account that just in April, a judicial officer did deny a similar request regarding to extending holiday visits. I'm going to again decline to extend holiday visitation until we have more input from Ms. Rosen. And again, going back to kind of my mantra for my entire decision today, is I don't think now's the time for significant change. I'm going to keep the exchange point as the Shell station. I'm not sure that that is working, to be fair, but I also don't believe mandating that the parents show up at each other's homes is going to be more appropriate. I would recommend that the parties maybe utilize some of the recommendations that Ms. Height has as far as some positive reinforcement for transferring between parents. Let's see where we left off. I obviously want included in the order to follow co-parent counseling / family counseling as recommended by the counselor. I also believe the counselor is recommending that we increase visitation with, or not visitation, excuse me, counseling with Lincoln to, is it 2 times per week? I don't think
1 time per week.
Oh, 1 time per week. Okay. So again, I think we can be generic and say I would like the parents to make sure the children are following the counselor's recommendations. It seems like that's agreed to anyway. The phone calls, it sounds like there's a request to change that. Is it, I mean, here, I guess my bias will show a little bit on children's phone calls, and Ms. Height kind of touched on this. I'm a big fan of child-led phone calls. I think it's one of the things that children still maintain control over when parents are separated. Everything else is being dictated for them when they can see the parent, when they can't see the parent, who they get to be with. But I think any child going through this should be able to tell and feel safe to tell their residential parent at the time, I would like to talk to mom, or I would like to talk to dad. And I really would like to see that happen in this scenario. Obviously, go ahead, Mr. Zandy.
I'm sorry, I didn't mean to interrupt. I thought that was a little, we're in agreement to that. We would just ask that the provision that neither parent interfere with the children's right to do that be included in that order.
Please do so, include that.
And so I'm assuming then that you're going to terminate his court-ordered telephone calls?
Yes, I'm not going to court order telephone calls. And when I talk about child-led phone calls, I also take that to mean if there's a day that a child doesn't feel like calling the other parent when they're not with them because that's just how the day is going, that's also okay. I wouldn't like to see there be no contact for 3, 4, 5 days. And I think both of you are, being the adults in the room, would probably encourage your child to reach out to the other parent to maintain that relationship. So I hope that is happening. But like Ms. Height said, I think that there are some parts of this whole process where we need to, especially boys who are older, they're not toddlers anymore, letting them have some say in when they talk to their parent, I think is really important. I'm just going through my list here. So weekly, every Wednesday, we've talked about family counseling. We talked about the exchange location, holidays. I would like to set a review date where Lincoln, in particular, has had a chance to undergo some additional counseling to see if there are additional recommendations that the counselor has, perhaps with drop-off locations and holiday schedule. So I'm proposing maybe a 60-day review, unless folks think that's too long, but I think that gives us some time for some counseling with child to be undertaken, but I'm open to that date.
60 is fine. I think actually 60 might not be long enough, but counsel and Ms. Height, I think, can accommodate that as necessary, the date.
Okay. Do you want me to set a date, or do you all want to note it on?
Yeah, I think setting a date just to keep it tracked is probably a good thing.
Okay. And you all probably know better than I, in 2024, will represented docket still be Tuesdays at 1?
Yes.
Yes. Okay.
So February.
Let's do
February 6th.
Yeah, let's do February. I have 27.
February. Oh, I thought, did you say?
Oh, I'm sorry. I went a whole month ahead. I put you 3 months out. Thank you. January. Nope.
What about February 6th?
Let's do February 6th. That sounds great. And then those were my notes, but am I missing a request that either party has made that you want me to rule on before you put that order together?
Screen time.
Not from in judge, just a presentation. Do you want us to put that on a pro se docket, or what's your preference on that?
Let's do, you could put it on a Wednesday pro se as long as it's done before the end of the year, because then they're taking me off of that.
I think council, I could probably craft the order with that input. I think that's pretty clear, but just in case, can we put it on Wednesday, December 6th?
Yes, that will work for me.
And that's at 9 a.m.
9 a.m. Mm-hmm. And then Ms. McLean, you talked about screen time. Are you meaning that when the children are with Mr. Moses that they can't have any screen time?
Yes.
I'm going to decline that request.
Your Honor?
Yes, go ahead, Ms. Height.
I am technically no longer on this case because I filed my final report.
Okay.
I'm fine to stay off this case, but I would like to know if I'm going to be on, if I should be reappointed. I'm going to defer to the parties and Your Honor on that.
Mr. Zandy, Ms. McLean.
Whatever the court decides is fine with us.
And I can draft supplemental order to that initial GAL one, but I guess we gotta, the three of us confer about what we want that to look like with fees and such.
Yeah, and I don't recall what the parties did originally with that, but I would like to reappoint Ms. Height and approve that some additional time. I do think that, again, with setting a review about 60 days out, I think it would be very helpful to the court to have your review of Rosen's recommendations and make any supplemental recommendations to the court.
Okay, Your Honor. Do you want it to be only related to that, or could I have a visit with the boys? Do you think that would be appropriate? I don't want to gum up the works, but I also would like to be able to give a clear report if I'm going to be reappointed.
I do think contact with the children, as would be done under an initial appointment, would make sense in this scenario.
Okay, thank you, Your Honor.
Thank you.
What are we thinking as far, well, Ms. Height can let us know as far as hours.
As far as hours? Okay, why don't I'll let the three of you communicate about that. If there isn't an agreement, then on December 6th, I can rule on that, but I'm guessing you all can figure that out. But if not, I'll deal with it on December 6th. 08.
All right,
I have us on is for review, excuse me, not review, but determination or order regarding, I believe, petitioner's motion for a restraining order. Does that sound correct to you, Mr. Baldwin?
That is correct, Your Honor. Their declarations and some of their filings touch on parenting plan and other issues. That's not actually before the court. The only issue functionally on today is a motion for restraining order that was granted on a temporary basis ex parte to prevent Miss Davis from returning to the home and removing any property from the home. The declarations in regard to that from the respondent are somewhat scant. The only sort of material in front of the court, the initial petition from Mr. Davis identifying concerns about items from the home being taken. Ms. Davis responded on October 9th, indicating a denial functionally that she had taken anything from the home, and somewhat of an accusation that Mr. Davis had indicated multiple times that he didn't even know why he had filed this, and that she wanted to go home to get items without identifying what they were. The response from Mr. Davis on October 27th outlines what I think the clear concern and issue is, preliminarily indicating that from the period of filing the dissolution paperwork in June to filing for the restraining order initially, there were instances where Miss Davis was listing items from within the home for sale that had been taken. Some Facebook posts he had been able to screen capture, by no means all of what he had seen, but what he was able to sort of show the court as a representative sample were home items that were being sold. And he recounts an incident in July where individuals showed up at the home at Miss Davis' instruction, basically because they had purchased a hutch that was still inside the home, that he felt under the circumstances he had no choice but to provide to them based on both their and her recitation that they had purchased the hutch from her. He is concerned that without this order, items of the marital community that would be subject to consideration or division would be removed from the home. It is a fairly standard order, especially when there are situations of such concern. Mr. Davis vehemently denies that he had given any indication that he was not aware of why he filed this or didn't believe he had a basis to file. He has concerns both for the safety of the home and though not necessarily at this time to the degree that he's proposing or made a motion for any physical protection for the children, concerns with the overall conduct of Miss Davis. Some of that is evidence in the text messages that are attached to his declaration from October 27th, specifically in Exhibit C, that show worry that money is the only and primary motivator for Miss Davis at this point, and that without an order protecting the home or its assets, that Miss Davis would either return to the home and exert improper influence on him or their child. But I think just as much or more of a concern would be that she would return to the home and either reduce the value of the residential asset or remove items from the home to sell without any sort of equalization in the assets. So we're asking the court to grant the restraining order as proposed, believe that there's a sufficient basis for the court to grant such relief, and that the declarations and materials submitted by Miss Davis don't adequately or in any meaningful way provide the court with any basis not to grant the relief requested. I think the hope is that the parties can work out a resolution. The court might be able to see from the record that originally the matter was set over because there was some discussion by the parties beforehand that a resolution might be able to be reached. When that didn't happen, or when the restraining order wasn't dropped as part of that court proceeding, it led to some of the more vitriolic text messages that are referenced by Mr. Davis. And the hope is that the parties can ultimately work on a resolution. The restraining order to restrain access to the property for concerns for safety of the assets of the property functionally would go away once the divorce is finalized and the property is able to be distributed and resolved. But at this point, Mr. Davis has concerns that he identifies very clearly that justify consideration and concern by the court with marital community items being sold, and really nothing before the court other than a general denial of any such conduct that refutes the claims by Mr. Davis.
Thank you, Mr. Baldwin. So Ms. Davis, I'm going to turn it over to you. I have reviewed, and today we're just here on the restraining order.
Okay.
So I'm going to ask you, I did receive your declaration and review it regarding your opposition to the restraining order and why you don't believe it's necessary. What else would you like the court to know?
Well, I wasn't able to submit my text messages, but on September 28th, I was at our storage where those said items were that I had on Facebook. And I had already told Mr. Davis that I was setting those items aside to sell them. And he said, he responded, just don't sell my stuff, please. And he told me twice that day in a text message, take what you want and leave the rest.
Understood. Thank you. Ms. Davis, anything else you want the court to know?
And about the hutch, he also knew that those people were coming to the house because I had told him prior. And when they got there, he didn't let them take it. And then we discussed it. And he told me in a text message, tell them to come get it. It's empty now.
So in looking at this case, Ms. Davis, thank you. I appreciate your argument today. I have reviewed the pleadings. As it pertains solely to the restraining order, I look at this case in terms of, I would like a civil protection order. Do I think more likely than not that the petitioner for this motion is entitled to the relief they're requesting? Obviously, there's a bit of he said, she said in this scenario occurring here, which would be difficult for me to make a decision on. But what I find particularly helpful to the court is the declaration of Shelby Heimer, if I'm pronouncing that correctly. I think that does, for this court, push me over the burden of proof on that more likely than not basis, because it does document an independent third-party observer seeing things be taken. So in that regard, I am going to find more likely than not that the restraining order to protect property, meaning restraining Ms. Davis from coming to the home and taking items from the home, should be granted. What, Mr. Baldwin, was your client asking this to last for a specific time period? I haven't looked at that yet.
Let me look, Your Honor, and I apologize. I'm double checking the motion to see what was requested. It was filed pro se.
Yeah,
so I don't recall. I think in this situation, I guess I would ask the court to, at the very least, get a fixed term of a year, if not in the alternative, set it for the pendency of the dissolution action until final orders are entered, or at a future date that the court were to strike the restraint provision. We did also have, Your Honor, just to confirm, there was restraint from going to the home and taking the items. There was also the protect property, preventing taking, hiding, borrowing, selling any
Yes.
property in the community. And I wanted to make sure that the court's intention was that also be marked, because that would protect property that's in the storage unit as well as in the primary residence.
That is, we would like, and in the temporary order, that's number 13. I don't know what number it is when I don't have a final order. So if you want to send one over, please do so. But what I will rule today is let's put it in a 1-year term. And then please do include the protect property section that, at least in the temporary order, is number 13.
Okay. Yes, Judge. And since this had been sent over a handful of times, I was anticipating you may not have the documents still. I should be able to get those over to the court for ex parte signature first thing tomorrow.
That's great. I will be here at least all morning, if not till about 2 o'clock tomorrow. So I will get that signed when I see it. Ms. Davis, do you have any questions for the court today?
Yeah, can I take my clothes?
Does Ms. Davis still have personal belongings at the home?
In the storage.
What I'll say is, if she can give me a list of any items, I can reach out to my client and confirm anything that he agrees is hers. I mean, if she has her clothing, I think that should be released to her. I just want to confirm with him that things haven't already been taken from the storage unit. So I can't say for sure.
Let's do this. Ms. Davis, thank you for pointing that out. Under, at least on the temporary order, it would be number 16 under other orders. Let's include language that specifically states that petitioner is to identify personal belongings of respondent.
And sorry, I think she's the respondent. So should she be identifying to me what she's going to be wanting, or you're wanting me to authorize what she can take? Just to
the petitioner is to identify her personal belongings and have those boxed up and returned to her.
Okay. Perfect.
Okay.
I apologize, Judge. My brain was going a different direction, so the party names were inverse to what I was expecting. So that's on me.
And when I'm saying petitioner respondent, I'm just looking at the, I guess, initial caption of the case. So yes, Mr. Davis to identify and box up the personal belongings of Holly Davis and make sure that those are returned to her.
Yeah. Perfect.
Okay. Thank you both.
Thank you, Judge.
Okay. Thank you. Anything I've missed?
No.
Okay. We will go ahead and go off docket.